220118119 NO Andrea Dent versus Marinos Benitez.
Council appearances for the record.
Your Honor, Mike Weaver on behalf of the defendant and moving party.
Your Honor, Freddie Sackler appearing on behalf of the plaintiff.
Okay, this afternoon, well, this morning, still.
Got one more appearance, Judge.
I'm sorry, Your Honor. Shelley Lee Griffin appearing on behalf of the defendant as well.
Okay, Ms. Griffin. Okay, we're here today for the evidence you're hearing relative to the issue of the costs and fees that will be allocated in this matter. The court previously heard a motion relative to the motion for costs and indicated that the defendant is entitled to costs. This evidence you're hearing is to determine the amount.
Okay.
Mr. Weaver.
You had said bring someone to cross-examine you, so I brought Ms. Griffin. So I was going to just take the oath and she can ask me questions, unless you just want me to say it, Judge.
No, what we'll do is, what you can start is a statement relative to it, and then she'll take your testimony relative to your practice and the like.
Fair enough, Judge. Your Honor, this is candidly a case that probably should have never been brought, let alone tried. And we'll go through the State Bar of Michigan when Ms. Griffin asked me some questions. This case, as a court witness, took on an additional component, I think largely because Mr. Sakala represents his sister. There was a stated purpose to punish Marinos Benitez. Everybody knew that Marinos was disabled, and everybody knew that he would not have the ability to pay any judgment that would have been rendered against him. I say that it took on a different element, and that's evidenced by a few things. For example, Dr. Taylor's deposition. My examination was about 30 or 35 or maybe 40 pages. The plaintiff's examination was extensive and lasted for hours and hours and hours. The court's aware of that, of course, because we had to have substantial arguments, taking time away from the jury, where we had to rule on objections on Dr. Taylor's deposition. Likewise, the deposition of Dr. Kislarian was extended for no good reason. Plaintiff, certainly at the behest of her attorney, secretly tape recorded Dr. Kislarian, which is contrary to the Michigan court rules. That deposition, again, my examination was, I'm estimating 30 pages or so, and the plaintiff's examination was another 100 pages or so. The court ultimately, in our mind, properly struck that whole line of questioning because the tape recording was improper and contrary to the Michigan court rules. Dr. Ager's deposition likewise was much longer than it needed to be. And again, I think for purposes of punishing my client. My client did in fact issue an offer of judgment. That is Exhibit 1. The first offer of judgment was in January of 2024. And the reason that I convinced my client to do that offer of judgment is I said, you're going to spend a lot of money defending this case. If you don't try to settle it, you're just going to throw money, good money after bad. There was, in my recall, never a response to that offer of judgment. So then later on, Judge, leading up to trial, and the trial was in December, on October 3rd, we sent another offer of judgment for $1,000. That's Exhibit 4. Plaintiff then gave a counter offer of judgment in the amount of $80,000. What's troubling about that, Judge, is the very first time that I talked to Mr. Sakala, that was his demand then. After that, the case was developed in great detail, showing that this was a case that did not have merit, and yet his demand never changed. This was a case where my client's father and mother had spent Well, you're gonna hear over $200,000 in the end, trying this case. And, Mr. Sakala did not take that into account at all. But in any event, we had a jury trial, we had a jury verdict that was a no cost, zero money. So as it turns out, our offer of judgment was much closer to the right number than plaintiff's $80,000 offer of judgment. He calls it a counter or response, but I think technically under 2.405, it's deemed an offer of judgment. So the median number is somewhere in the $40,000 range, and certainly the plaintiff did not get to that number or anywhere close, and so they owe fees. I don't think I have to go into plaintiff's cases that he relied upon, Your Honor, but I can. I don't think we have to because we've really addressed it at the first hearing.
We did.
You're going to hear, Judge, that my client paid, consistent with 2.405, or owes $61,951 in fees. Exhibit 7 to this hearing is $25,893 in costs that my client paid. Exhibit 10 is the number $12,835 in costs that my client paid. These deposition transcripts were expensive. Ordering the records was expensive. There was a lot of expenses that my client paid. That in and of itself is $38,000. So you can see that the number is somewhere close to $100,000, whatever 25.8 plus 12.8 plus 61.9. And I can do that math with a calculator to make sure we're okay. Certainly, as the court ruled, the fees are appropriate. I'm sorry, awarding of fees and costs is appropriate. It's just a matter of the amount. When I look at table 3 of the State Bar, that talks about equity partners and shareholders. Now, my contractual rate, Your Honor, is $400 an hour, $290 an hour for associates. Under table 3, which is exhibit 6, page 5, the 75th percentile is $500 an hour, the 95th percentile is $730 an hour, so my rates are under that. Table 4, which is exhibit 6, page 6, talks about how long someone's practiced. I've been practicing since 1990, Your Honor. And the 75th percentile is $450. The 95th percentile is $645 per hour. Table 5, which is also on page 6 of Exhibit 6, the 75th percentile, 75th percentile is $588 an hour. The 95th percentile is $748 an hour, so I'm under on both of those. Looking at Table 6, which is on page 7 of Exhibit 6, for Oakland County south of M59, the rates are $425 an hour for the 75th percentile. It's $600 an hour for the 95th percentile. And the only area where my rate could arguably be above the State Bar is Table 6, where it talks about Wayne County. The 75th percentile is $350, and the 95th percentile is $425. And the last table to look at, Your Honor, is Table 7, which is on Exhibit 6, page 9. And there, the 75th percentile is $400 an hour, exactly what I charge. And the 95th percentile is $650 per hour. And I'm sorry, there's one more table, Table 9. It talks about rates in the Wayne County Circuit Court for the 75th percentile are $425 and $650 for the 95th percentile. Oakland County is $425 for the 75th percentile and $637 for the 95th percentile. So my average hourly rate is below the average hourly rate on every single table, except for it's $50 an hour higher than the hourly rate in one table. And that's Table 6, found on page 7 of Exhibit 6. So it would be pretty difficult to say that my rate is unreasonable based upon even just saying that 75th percentile. Because I have a trial lawyer's ego, Your Honor, I'd say I'm 95th percentile, but I don't need to make that argument today because the 75th percentile really carries the day on the issue. As it relates to the hours expended, I really just kind of focused on some points that the plaintiff made in their summary. For example, he couldn't believe that Dr. Taylor's deposition was only a little over 4 hours, but I charged 6.3 hours. I can explain that. My client pays portal to portal. So from the time I left my office to the time I came back to my office. Now, the deposition ended after, I think, 9 o'clock at night. So I didn't come back to the office, but I looked at my clock when I drove past the office because it's an in-between point between my home and Ann Arbor where we took the deposition. That 6.3 hours is exactly what I expended. And in addition, I spent about 25 minutes with the doctor preparing him for the deposition. So I don't even think I billed for that, but I could scour the bills and find out one way or the other. He also had some concerns about the motions eliminated. There were 12 of them. Now, what I did on that, Judge, is I had an associate write them at a lower rate. I had Brianna Combs write them. She's been a lawyer since 2021. She wrote 10 motions eliminate and responded to 2 of them. I don't see where the plaintiff makes a stink about those charges. Brianna Combs bills at a lower rate than me at $290. I reviewed those motions to make sure they were good to go, and I didn't bill for any of that time. Then we went to argue the motions, and the court will recall we had a long argument about 12 motions. Your Honor, you had read them very carefully. We're pretty ready to rule on them when we got there. Just had to take some arguments. But I billed about a little less than an hour for each one preparing for them. Your Honor, they fill, I don't have to tell you because you probably print like me. There were 2 banker's boxes full of documents that I reviewed, and I billed 10 hours for it. 10.8, I think, is the exact number. In no way, shape, or form are those hours unreasonable. Those are a couple of the billing entries that the plaintiff criticized in their response to my motion. But there's more, Judge, that I think really sets the tone for this case. At the very first deposition that I took, Mr. Sakala stood over the table and stood over me at the end of the table and said, "You'll back down. Everybody backs down from me." And that really was a bit startling because I don't hear lawyers talk like that very often, but there's more. Later on in this case, Mr. Sakala boasted to my assistant, Amy Wells, "Weaver needs to be humbled." Well, I don't know. That doesn't sound like somebody who's trying to settle a case.
Objection, Your Honor. These are hearsay statements. They're not true, and they're not supported by anything. I'm not a party to this case. They're not a party admission. I haven't been called as a witness in this case, so
This is a hearing. This isn't. It's just a hearing.
I understand, but the self-serving statements of things that I said to a third party are just they're just not true, and I don't even need to get into that because they're hearsay.
Well, it's not offered for the truth of the matter asserted, Judge, because I don't need to be humbled. I am humble, and especially during this Lenten season, Your Honor, I'm incredibly humbled. I'm blessed to be walking the earth. But he said it to Amy Wells. I don't know why he said it. I don't know what he was trying to prove, but he said it, and that just really tells us everything we need to know about why this case had to be tried. They knew from day one, Judge. They knew from day one that Marinos Benitez was disabled and would never be able to pay the judgment. You'll hear that since this trial and the trauma inflicted upon him during the trial, and perhaps Ms. Dent will be pleased with this, he's been an inpatient for 9 days. He's barely left the home. They tried to go on a vacation. He wouldn't. He wouldn't participate. He is not back at school. This trial was an incredibly traumatic experience for him. But I suppose that's not necessarily a factor, Your Honor. But I think it's important. I think the court recognized when Mr. Sakala was trying to accuse Marinos of faking it on the stand. I think the court got a full view of what this case was really all about. And Your Honor, with that, I don't have anything else to add other than I would have Ms. Griffin just lay the background that's set forth in my affidavit, which is found as Exhibit 5.
Okay, thank you. Mr. Weaver, would you raise your right hand, please? Do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth?
I do, Your Honor.
Thank you. Ms. Griffin?
Thank you, Your Honor. Mr. Weaver, when were you licensed to practice law?
I was licensed in November of 1990.
Have you ever been disciplined by the State Bar of Michigan?
I have not.
Have you been admitted to practice pro hoc in other states?
I have, this is from my recall, Florida, Indiana, I think Wisconsin, Pennsylvania. Pennsylvania might have been a federal court, so I was just admitted in the federal court there. I think I was also admitted in Colorado. I also have a license in Arizona that I've put on hold because I haven't been practicing out there, but I'm in the process of kind of reinstating that.
Have you ever faced discipline from any of those states?
I have not.
Did you execute the affidavit that's attached as Exhibit 5?
I did.
And is it accurate and truthful?
It is accurate and truthful.
Have you been recognized as a super lawyer in the state of Michigan for the last 9 years?
I have been.
Have you been an AV rated lawyer in Martindale-Hubbell for many years?
I have been, and that you have to get peers to vouch for you. They call random individuals who've had either know you or have had cases with you, and they vouch for whether or not you should be AV rated.
Are you recognized in Best Lawyers in America for commercial litigation and labor and employment, along with product liability?
I am in all three areas.
Are you an equity partner at Plunkett Cooney?
I'm an equity partner since 1997.
Are you familiar with Ms. Chidiak?
I am familiar with Ms. Chidiak.
How long has she been licensed to practice in the state of Michigan?
Chloe Chidiak, and Your Honor, you may remember Ms. Chidiak was with me at trial a little bit towards the end. She's been licensed since November of 2022.
What type of work did she do on this file?
On this file, she did a lot of research work. She helped me with some drafting of different documents that were filed with the court.
What was her hourly rate?
Her hourly rate, as agreed upon by the client, was $290 per hour.
Did you supervise her work?
I supervised all of her work,
And did you review her work?
every bit of it before it went to the client and ultimately to the court.
Was her work exemplary?
It was very exemplary. She does fantastic work.
Is her rate reasonable?
It is a reasonable rate consistent with the State Bar of Michigan law of economics, I think is what the survey's called.
Is the contractual rate agreed upon with the client?
It is at $290 per hour for Ms. Chidiak.
And were her billings reasonable and necessary?
Her billings were reasonable and necessary, and her work was reasonable and necessary. Then we could go to page 7.
Were all of your activities reasonable and necessary?
They were.
What were the total hours and fees, or were the total hours and fees within the purview of MCR 2.405?
Yeah, I believe if the court looks at Exhibit 9, page 8, there's 176.4 hours that fall within the window of 2.405. That's my calculation, and it's 61,951.50.
How many hours was that again? I'm sorry.
176.4 plus today, Your Honor.
Okay, thank you. You may continue, Ms. Griffin.
With regards to Brianna Combs, how long has she been licensed to practice?
She has been licensed since 2021.
And what more did she do that totaled? We've talked about the motions in limine, but she totaled 28.9 hours.
Yep, she wrote 10 motions in limine. She responded to plaintiff's motions in limine. She also did some other research on this file and billed 28.9 hours, which I supervised all of it, reviewed all of her documents before they were finalized and sent to the client and filed with the court.
With respect to those motions, how many were eliminated?
Well, I think almost every one of the motions in limine were granted for us, and I think, if I remember correctly, the plaintiff's motions were denied.
How many of those, did she prepare responses to the plaintiff's motions in limine?
She did to both of them. I jumped ahead on you, I apologize.
Okay. Were her billings reasonable and necessary?
They were.
Was the quality of her work, did it justify an hourly rate of $290 per hour?
Yeah, it definitely did. In fact, one of the big motions in limine the court may recall is the plaintiff secretly recorded Dr. Keslarian, and there was a significant stretch of cross-examination on the secret recording. That motion in limine was, I thought, quite important to this case and really well done. And that was 100% Ms. Combs' work, and it was outstanding.
Did she also write a motion for summary disposition?
She, in my recalls that Brianna Combs did write the motion for summary disposition. It was denied, but it was well written as well. I don't think we need to go into plaintiff's case law. So at the bottom of page 9.
Okay.
Just additional fees.
Okay.
So I would just say this, Your Honor, Ms. Griffin was kind enough to assist me today and work on this outline of our questions. And has an hour into this case, and I had, for preparing for today, about 2.5 hours, and I'm including the time that we spend here today. So on top of the 176.4, I would add 3.5 hours, and Ms. Griffin is an equity partner here at the firm, so she would also bill at $400 per hour.
Okay. Is there anything additional, Mr. Weaver?
Nothing from us, Your Honor.
Mr. Sakala, briefly?
Yes, Judge. Mr. Weaver, when you filed your brief on this motion, your first sentence said, defendant has been diagnosed with schizophrenia, is unemployed, and has no reasonable expectation of satisfying a judgment due to his condition. Is that a truthful statement that you made to the court in your pleadings?
Well, when I look at the motion, that's not the first sentence, and I look at the brief, it's the second sentence, and it's true. My client has, as you well know, Mr. Sakala, has not been able to seek employment, has not been able to maintain employment, has not returned to school. He's been an inpatient for 9 days since the trial. He was called a liar and a faker on the stand. He's incredibly traumatized by this trial.
Sir, didn't the jury on element 2 find that your defendant knowingly or recklessly committed or made the threat to Ms. Dent?
Well, I don't think that's the way the language was worded, but the bottom line with the jury verdict was they awarded 0 to Ms. Dent, your sister. They found that she did not sustain any injury or damages.
In addition to your brief making that statement, you just stated on the record as an officer of the court that you believed that spending any money on this case would be throwing good money after bad money.
I don't know where it is in the brief, but I think I said that today, that without breaching my confidence and privilege of my client, it was clear to me that if Marinos were to be found liable, that he would be completely unable to pay. And so I guess that fits the definition of the old wives' tale, or the old statement of you're throwing good money after bad.
And you also made the statement that everybody, and you just said it was clear to you, you couldn't tell me the status of your client, but you made the statement today that everybody knew he was not collectible.
So is there a question?
Is that a true statement? As an officer of the court, did you believe that it was very clear to you that Marinos was not collectible?
I knew Marinos was still a college student. I knew that he was struggling to graduate. I knew that he was disabled. I listened to the testimony of Dr. Taylor. I read the records from the University of Michigan. I read the records from the institution where he went from the University of Michigan. It was clear to me based upon, and I also spoke to his parents, but it was clear to me based upon that this is a young man who unfortunately would never be able to sustain any gainful employment. Especially in light of the fact that I think your demand to the jury was about $600,000. There would have been absolutely no way that Marinos Benitez could have satisfied that judgment.
Ms. Dent accepted the case evaluation award of $80,000, correct?
I honestly don't remember that. I just don't remember.
Marinos did not accept the case evaluation award of $80,000, did he?
He did not. He instead issued an offer of judgment, in fact, 2 of them, and they were met with a counter of an offer of judgment that was the exact same amount of the case evaluation award, which he had already rejected. It was also the same amount that you mentioned to me and demanded for me on the very first conversation we had. I can tell you exactly where I was standing at the time we had that telephone conference, if you'd like to know.
Sir, did you said that Plunkett and Cooney has incurred as a build the defendants in this case 200,000, correct? Over 200,000, that's your testimony today?
I don't know what our full number is. What I can testify to is a number that I believe falls within 2.405. My client can testify, Mr. Michael Berditzis, Dr. Michael Berditzis can testify to the total bills, because you recall, I was not the first lawyer on this case. I think that their bills exceed $200,000 in total.
How much are their bills total to Plunkett and Cooney on this matter?
As I sit here right now, I don't know, but Michael tells me it might be about $154,270 plus costs that were $25,893.
So above 175,000, correct?
With the costs, yes.
And that, just for the record, we're on Zoom, but your client's sitting next to you. Do you believe that the number he just gave you is an accurate number, and are you testifying to that number today?
I trust his numbers. I've not sat down and looked at all the bills. I really only looked at the bills that fell within what I believe to be the appropriate time frame under 2.405.
Did you take into account the amount of money that the firm was spending on the case in comparison to the case evaluation award and your offer of judgment of $1,000?
I don't know what you mean by take into account. If you're asking me, do I think that our activities were reasonable and necessary? Yes. There's no doubt about it, especially when I'm challenged by a lawyer that no one backs down to him. It was clear from the fact that the demand never changed from my very first conversation to the last quote unquote offer of judgment that was filed on behalf of the plaintiff. It was still $80,000. And then, even worse, at trial, the demand was somewhere around $600,000. So yes, the activities that my law firm undertook were reasonable and necessary.
Okay. The complaint in this case was a 1-count intentional infliction of emotional distress, correct?
Yes.
Your total fees, I believe, or your total hours for fees, I believe Exhibit 7 for attorneys is 168.3 hours. Can you look at Exhibit 7? And I'm not talking about paralegals. I'm not talking about Miss Wells or Miss.
So Exhibit 7 is the list of costs for about $25,000.
Okay, well, I have your a thing called. Do you see this document here?
What
Yeah,
exhibit
exhibit
is it? What exhibit is it?
I believe it was Exhibit 7.
No, it's not. Exhibit 7 says external legal services.
It's Exhibit 9.
Exhibit 9. Looking at Exhibit 9, sir, you have attorney recap in the middle of the page, or
Yep, it's on each page of the document.
okay. And on that page under attorney recap, you have hours for yourself, Miss Combs, and Miss is it Chidak?
Chidiac?
Okay. And the total hours, those are 3 attorneys, correct?
That's correct.
And their total hours is 168.3, correct?
Whatever the 111.2 plus 28.9 plus 28.2. I should also point out that Chloe Chidiac has a 0.8 that she billed at $0. She did that work gratis for the client.
Okay. So
I could have had lawyers do the work that Ms. Felder and Ms. Wells did, but I thought it best to push that work down to somebody who would bill at a lower rate for the client. So instead of my rate of $400 an hour or the associate rate of $290, I had that work done, which totals 7.3 hours at $125 an hour, to try to make sure it was as reasonable as possible.
sir, on Exhibit 9, if you add up those 3 numbers, 111.2, 28.9, and 28.2, can you add those up? Does it come out to 168.3?
I have no reason not to trust your math. Do you want me to do it right now on a calculator? I can.
You will testify that you believe it's 168.3, then we can move on.
No, what I testified to is I'm going to trust your math. I would hope you wouldn't lie about that.
Sir,
But if you want me to do the math, I can do it.
No, I can count. Move on. Thank you.
All right, sir. The answer for the offer of judgment, the date you start your billing is October 23rd of 24, correct?
Are you referring to Exhibit 9 again?
Actually, they'd be two different dates. The answer was October 23rd, 24. Your first billing item that you're requesting from this court is October 26th of 24, correct?
That's what Exhibit 9 shows, yes.
And the trial in this case ended on December 5th of 24, correct?
I can look. It looks like December 6th, it looks like there's an entry by Chloe Chidiak. I don't know if the trial ended on the 5th or the 6th. She might have just recorded the date wrong because she came to trial that day.
But the last entry is on December 6th, correct?
Well, that's Ms. Chidiak's entry. My last entry is December 5th. I'm sorry, December 6th
Okay.
was day 7 of the trial, correct?
So the total business days between 10/23 of 24 and December 6th is 32 business days.
10/23, so there's 31 days.
The date of our answer to December 6th was 32 business days.
Well, I don't know how many business days it was because I don't know what day they fall, but it would be 8 calendar days in October. It would be 31 days in November. I think there's 31 and another 6 days in December. So however many of those days come out to be business days. But, you know, Mr. Sakala, I don't think I have to tell you this. This isn't a Monday through Friday job, and it's not a 9-to-5 job. This job is a career and a profession. And when I'm representing a client, especially in a trial that I believe has ill motive, I'm going to make sure that I can't hear you, Mr. Sakala. I'm going to make sure that I put in my very best effort for my client.
Sir, I don't see any billing records on weekend dates. I didn't look in detail. Do you want to tell me that you're billing for weekend time?
What's
Whatever
the point?
dates,
What's the point? What's the point? Tell me what the point is. I'm the trifecta. Where you
Okay.
going?
So it's 31 business days as I look at it, 31 business days from October 23rd of 24 to 12/5. If the court would accept that,
But what, why? I don't know why you need me to accept that. Why am I accepting that?
so, sir, according to your time records, you're billing Plunkett and Cooney. Somebody at Plunkett and Cooney is working on this case at about 2/3 of every business day from October of 23rd until December 5th.
well,
Take
I
the
would say,
168 and you divide it by.
hang on. There's
Well, I want to
multiple
get the
people.
math ready first.
Okay, well, is there a question? Make
Yeah,
a question.
there's a
You don't
question.
need to just give me a question.
Okay, so sir, if you take the 168 and you divide it by 31 business days, how much does that come out to?
I didn't know I needed a calculator
Why?
today.
I don't need, why are we doing that? That's irrelevant.
Sir,
However much time, no, I'm talking. This is the judge.
Judge,
That's irrelevant. How many, dividing it, that's your calculations. He gave you the hours and the time and what happened on each day. I don't know what the relevance is, and I really don't care what the relevance is in terms of doing some division to see how many hours. He gave you the specific tasks that were performed on those hours, on those days, and you can look at those, but we're not doing any esoteric math.
Okay.
So just stick with the basics.
Sir, do you believe, according to your records, in your exhibits, it appears that Plunkett and Cooney was working approximately 5+ hours a day on the Bernice case from October 23rd of 24 to December 5th of 24. Do you believe that's an accurate recollection?
Well, couple things, Mr. Sakala. It's Plunkett Cooney. There's no and that was changed long before you even began practicing law. But that being said, you ended it at December 5th. We know the trial lasted to December 6th. So your math would be flawed. But Mr. Sakala, I get into the office at about 4:45 every morning. I leave at 6:30 p.m. every night. I'm not the only person that worked on this file. I will say this, that the 7 days that I spent with you attacking a young disabled man, it was probably 80 or 90% of my day was spent in trial with you.
Moving on, sir. Exhibit 9, Miss Combs, Miss Combs' hourly rate, that's $2.90 an hour, correct?
Yes,
All right. And Miss Chadiak Chloe's hourly rate is also $2.90 an hour.
all associates are billed at $2.90 per hour.
Is there any attorneys at Plunkett and Cooney that are billed lower than $2.90 an hour, if you're aware?
And it's not Plunkett and Cooney. On this file, the contractual agreement with the client was $400 an hour for shareholders and $290 an hour for associates. So on this file, absolutely not.
What does a junior attorney make at Plunkett and Cooney?
I don't know. I don't set payroll.
Moving forward, exhibit, you've got an exhibit outlining your expenses. I believe that's exhibit 9 also. It's called
Well,
legal
There's
services.
$477 of expenses that we advanced. $477.41.
Sir, I'm looking at external legal services. I'll show you the document right here.
It's not exhibit 9.
What exhibit is
It's
that?
not exhibit 9. You can't get your exhibit straight. It's
Okay, come on, Mr. Weaver. I understand. That's exhibit 7.
So you
Mr.
just
Sacco,
emailed
that's
your exhibit
exhibit
this
7.
morning, correct?
They were attached to the motion, and then I emailed them this morning to hopefully assist you, but it didn't work apparently.
Exhibit 7, sir, your expenses. You've got the first 7 items of expenses. You would agree are all items that occurred before October 23 of 24. All things that occurred before that, correct?
They were transcripts that were used at trial. If you read the court rules, transcripts that are used at trial, it can be billed. It doesn't matter when you paid for the transcript. You should know that.
So, sir, just let's be clear.
Except for the IMEs, which again were paid for, which were required for trial. Both Dr. Ager and Dr. Kislarian testified at trial via Beni Essay deposition.
All of these billing items totaling $11,179.25 were for work and were for cost that were prior to the offer of judgment rule allowing you to accept cost.
Well, it seems to me you're not following along. When you have a deposition transcript that's used at trial, that cost is passed on under the court rules. It's part of 2.405. The actual court rule that says you can use transcripts, I can't remember off the top of my head and bill for them.
I understand. But
the IMEs of Dr. Kislarian, which was $4,500, that was before. But the deposition of Dr. Agar, which was, it looks like it's $3,700, that was certainly something that was used at trial. You might recall you were late for that deposition, and we were required to wait for you, and we had to pay the doctor extra because you were late. In fact, I asked you to pay it, and I don't know if you ever did.
Sir, last time, the events 1 through 7.
He's already articulated that. Move on. You can make your argument. He stated his position on that. Let's move on. And I have a meeting at 12:30, so this is not going to drag on. You got 5 more minutes, Mr. Sacco, then we're going to have arguments.
No problem. Sir, you've testified, well, let's just confirm this. Your motion states this, but I want to confirm it. The acceptance of Marinos as a client did not preclude you from accepting any other clients at Plunkett and Cooney, correct?
Again, it's Plunkett Cooney. I think you're doing that on purpose, and I don't find it to be very funny. But in any event, I mean, listen, I try to take on every client that I believe needs a good defense. And so I took him on, and I took on others, and I still take on others every single day. At some point in time, at some place in my life, I guess I'll reach a capacity. I just haven't reached it yet. I'm blessed that I have a number of colleagues that assist me on my files, as you can see from the billings.
Right. So the answer is yes, it is correct that taking on Marinos Benitez did not preclude you from taking on any other cases.
That's correct.
The next one is the Bernices were a very new client to you. They came to you first in January of 2024, correct?
I don't remember the exact date they came to me, but they were new to me. They had been to a couple other lawyers who said they couldn't handle the case primarily because of your antics. And I said, I'd be happy to help them.
So, sir, the Bernices were not clients of Plunkett and Cooney prior to this case.
I'm not going to answer your question if you don't ask it properly.
The Bernices were not clients of Plunkett Cooney until this case.
As far as I know, this is the first matter they've brought to Plunkett Cooney. Do you want to talk about the skill that was required? Do you want to talk about the complicated nature? Do you want to talk about all the wood factors, or you just want to cherry pick?
He doesn't have to. Let him talk about what he wants to. You can make your argument, Mr.
Thank
Weaver, when it's time.
Thank you. Thank you, Your Honor.
Sir, motion in limiting that you had Ms. Combs work on and you worked on. Ms. Combs, would you agree billed for 25 hours to work on those motions in limiting, and you billed for 10.8 for drafting, reviewing, analyzing?
I reviewed only when I analyzed getting ready for oral argument. I didn't bill for reviewing the motions before she filed them. She billed whatever she billed, probably 20 or 25 hours. It was 11 motions in limine. I'm sorry, 10 motions in limine and responding to 2.
In review of Exhibit 9, the bills that you're requesting here, you've got hours added up for 10.8 on the motions in limiting, and Ms. Combs has 25 hours. Can you confirm those? Can you total those up and confirm those?
Tell me the pages. I'll go ahead and do the math for you, Mr. Sakala.
All right, on 10/28/24, Combs bills 2.7 and 10.
We're not gonna do that math again, Mr. Weaver. If you did this math before, just confirm that you did the math and it's accurate, please.
Yeah, I know I billed 10.9 hours for sure. I haven't added up Ms. Combs' hours. But if that's what it's reflected on Exhibit 9, those are the bills that actually went to the client. So I'm gonna trust that that's the time she spent.
You would agree that if you drafted everything that you wouldn't need to review it, correct?
I didn't draft any of these documents. I didn't draft any of the motions in limine. I didn't draft the responses to the motion in limine. What I did was bill for reviewing them so that I could argue them to Judge Gibson. That's what I billed for.
You believe that Ms. Combs was not talented enough to argue them?
That's not the case at all. She's an appellate lawyer and I'm a trial lawyer. So she's a 4-year lawyer and I'm a 35-year lawyer. I have a client that is being attacked. I have a disabled client, and I wanted to make sure that if something went south, I could stand in front of the client and say, this is on me. So that's why I argued those motions.
Is there any reason you didn't draft them?
Yes, because I typically have folks in our appellate department draft a lot of my motions. They're smarter than me.
No further questions, Judge.
Mr. Weaver, argument.
Do you want to hear from Dr. Benitez, Your Honor? He can just tell you what they've spent. If it's not germane to your decision, I'm not going to bother you.
No, it's not. We're just dealing with 2.405. What's permissible under 2.405.
All right, Judge. I think we've laid this out in our filings with the court, looking at the wood factors, the skill, time, and labor involved. This was an incredibly labor-intensive case. It was maybe what I would argue is a bit of a knife fight. Being surprised with secret recordings, listening to a lawyer cross-examine a treating physician for 4 hours, having to combat false narratives constantly from the plaintiff's side, having Dr. Shiner come in and, in my humble opinion, mislead or attempt to mislead this jury, having to have mental health experts sort of on both sides. We had to have mental health experts that testified and were examined and cross-examined that said Ms. Dent was either damaged or not. And then we had a mental health professional come in and say that Marinos was either damaged or not. We had two of them, one on each side, Dr. Taylor and Dr. Shiner. It's pretty rare that you have that type of competing interests from mental health professionals, both for and against the plaintiff and for and against the defendant. There were 4,000 pages of records, I believe, from the University of Michigan alone. And when I look at all the work that went into this case, there is no question in my mind that the fees were reasonable and necessary. So I look at the skill, time, and labor involved. There's no doubt about it that humbly, a newer lawyer might not have had the same result. Mr. Scala made it clear that he's tried some 60 cases in courts, and he certainly made it clear that he's a very formidable foe. I agree that accepting this case did not prevent me from taking on other cases. But as it relates to step 3 or factor 3, the fee customarily charged in the locality, we've shown under the State Bar of Michigan survey that absolutely the fee hourly amount was reasonable. The amount in question, the results received, well, the plaintiff never had a demand less than $80,000. There was no choice for my client but to reject that. And then the demand at trial was about $600,000 and the verdict was $0. So the amount in question is substantial. The result achieved is substantial. The expense incurred, there's some $40,000 worth of expenses incurred. There isn't a long relationship with the Bernitzes family, but I certainly do have an incredibly close relationship with them now. Marinos sends me an email every now and then, albeit somewhat disjointed. Professional standing and experience as an attorney. I've practiced in multiple states. I've tried somewhere around 80 or 90 cases. I'm AV rated. I just resigned my membership with ABOTA, which is also an organization that you have to be voted in, and it's based upon trying a certain number of cases. I'm recognized in best lawyers in America in 3 different areas, and my standing and experience in the professional community is, I think, unblemished. I've had no disciplines. I don't think every lawyer that's on this Zoom can say that. And then whether the fee was fixed or contingent, and I'm not talking about Ms. Griffin, whether the fee was fixed or contingent, it was a hourly fee. And so we're looking at the standards in Wood, looking at the standards in Finney versus Perlmutter, it's clear that the hours were reasonable. There's been no testimony from an expert on the other side, and frankly, no testimony or questioning from Mr. Sakala that would indicate that the hours or the rates were unreasonable. I would have thought that if he was really going to challenge this, he'd have hired an expert to say, Weaver's no good as a lawyer. Weaver doesn't have any standing or experience in the community. Weaver's rate is outrageous and the hours are outrageous, but we didn't see an expert retained by Mr. Sakala. Instead, once again, I think he's led his sister down the wrong path. And we're entitled to, Your Honor, $61,951 in fees plus 3.5 hours for today. So that'd be another $1,500, $1,600 roughly. $12,835 in costs is noted in Exhibit 10. $25,893 in costs is noted in Exhibit 7. And with that, Your Honor, unless you have questions, I have nothing further.
Mrs. Ackman?
Your Honor, first, the factors in Purdue and the cases cited by counsel, and we are already past the question of whether or not the offer of judgment was empty. But with that said, that'll be for the Court of Appeals. This issue, Judge, is pretty simple. First, counsel's admitted, and the court understands, that there's no novelty on this case. This is a 1-count complaint for intentional infliction of emotional distress. So, 1. 2, counsel keeps arguing that the case was opposing counsel, myself, was not smart, not capable, hints to I'm being disciplined by the state bar. Clearly, he didn't see me as a formidable advocate. and not in not requiring his stellar skills. Counsel clearly did not understands that his client was uncollectible. No, everyone knew he was uncollectible. From Mr. Weaver's own understanding of this case, from his inside knowledge, his quote is that it would be throwing money, good money at bad money. That this would be an empty judgment. The factors that counsel needs to look at, whether or not it was a reasonable or good result, judge, weigh heavily on spending $200,000 or $175,000 with Mr. Weaver alone, the third attorney, and Mr. Weaver's office taking $175,000 on a case where they knew the person wasn't their client was completely uncollectible. That needs to be factored into this case. Moving forward, counsel's admitted very specifically that the firm had no prior relationship with the individual, with the Bernice's. There's no question on that factor. The counsel's also admitted that the difficulty on this case, I mean, everybody knew that he was sick, he had schizophrenia. There was really nothing to prove here. Getting back to novelty. So our position, Judge, is first, one, the case was simple. The paralegal in this case, or the attorneys in this case, Ms. Combs, who did the work, looks like to be doing the lion's share of work or a lot of work, was more than capable at an hourly rate of $290 to handle this case that was simple. She was a junior attorney there. She had more skill, as Mr. Weaver says, than him when it comes to writing things. She was talented, exemplary. There is no reason she shouldn't have been litigating this case. Why are we putting why is it reasonable for a seasoned attorney with 80 trials under his belt to verdict to be charging almost $175,000 in fees and costs to an uncollectible client to litigate a case that's of no value, and then just offer $1,000 as an offer of judgment and not accept the $80,000 in case eval fees, which would have ended this case? It makes no logical sense. Moving forward, Judge, we would argue very simply that the fees in this case are exaggerated, that we have 3 attorneys working on a file and 2 paralegals, 5 people from the firm for 175 total hours. The attorney's work alone in the last month totals about 2/3 of a business day every day from October 23rd of 24 to 12/6 of 24. No logical person would believe that a law firm like Plunkett and Cooney would have somebody assigned to this case 2/3 of every day of every business day the place was open. It doesn't. I'm not going to get into fees more than the motion in limine, which clearly articulates that. You've got Ms. Combs writing it for 25 hours. You got Mr. Weaver building it for 10.8. You got 30 hours plus, or 35 hours and a little more on the motions in limine, which were pretty much copy and paste issues, when all of it could have been done by Mr. Weaver for maybe 10. Next, cost. Cost or cost. The rule is the rule. If you pay the cost before October 23rd of 24, which we all agree is the day this starts, if you pay the cost before that, it's the cost. You ordered the transcript. If you're using them at trial, it's fine, but you already bought them. He didn't buy them for the purposes of trial. Mr. Weaver thought this case was never going to go to trial. He bought them prior to this case going to trial. The records reflect that they were March 7th, 2024, 1,040. March 20th, 2024, we're talking the spring before trial, 996. April 12th, 24, 1,030. May 16th, 24, 4,512 and 50 cents. September 11th, 24, 1,000. October 26th, 24, 2,750. October 17th, 671. All of those things were paid for before, if my memory serves me right, before the motions of limiting were even heard. So I would tell you that they're all before the date. They were all, majority of them were paid for months before trial. The only ones that would be anywhere near the trial date would be October 16th and 17th, October 16th, 2,750, and October 17th, 671, which I believe are a little over a month before the, we might have started November 11th. I think we started and left Thanksgiving. I can't remember, but probably within 3-4 weeks of the trial. Conclusion, Judge, that the cost need to be reduced by the amount of $11,179.25. And the fees need the hours spent by counsel on this case need to reflect the novelty of this case and the value of the case. And 168.3 hours in the month before trial, 2/3 of Plunkett and Cooney's daytime, is not a one-count complaint for intentional infliction of emotional distress. And I would argue to the court that they should be reduced by at least taking out the paralegals, the associate attorneys, and applying Mr. Weaver's hours alone.
Briefly, Mr. Weaver.
Yeah, Your Honor, let me address this 2/3 of a day nonsense. There's 3 lawyers that are working on the file. If there's 5 hours billed per business day, quote unquote, to quote Mr. Sakala, that means they're each spending about 1.6 hours a day on this file. That doesn't make sense. You know what else? It ignores the fact that the last 7 days of billing are 7 or 8 hours or 6 or 7 or 8 hours a day because we're in trial. I'm present in the courthouse in trial. So that doesn't make sense. Your Honor, plaintiff said Weaver never thought this would go to trial. Maybe Mr. Sakala wasn't listening to my remarks. He challenged me on the first day that I met him in a deposition that everybody backs down from him. We took 3 Debene essay depositions. Do you really think that is indicative of the lawyer who doesn't think the matter is going to go to trial? That statement is nonsense. He says reduce the costs and fees. You know what he should do? Why don't we produce his retainer, his hours, his hourly rate, his fees, and his costs? Let's see if mine are reasonable when we compare the two. He had 2 lawyers at trial. I had Ms. Chidiak there one day, and that's because she was primarily helping me with the exhibits that were being shown to the jury during my closing argument. He had 2 lawyers present every single day of the trial. To suggest that we should reduce our time is nonsense. He points to not one entry that is quote unquote exaggerated. As it relates to the transcripts, Judge, the rule is very clear. If you use the transcript, it's submitted to the court. It doesn't matter when you paid for it. That only makes sense because we take Debene essay depositions sometimes months and months before trial. But then those transcripts are either read to the jury or played to the jury. We have to have arguments with the court on objections. He said to you, as what I believe to be a veiled threat, that'll be for appeal. He's not filed a timely appeal. His appellate period has expired. He may appeal this decision, but he's not going to appeal the verdict. He's nodding his head yes, so the record's clear. Before he even gets a ruling from you, Your Honor, he's telling you that he's going to appeal this ruling, which is just nonsense. He said, oh, I never thought opposing counsel was smart. I said very clearly in my remarks, he's a formidable foe. He told us he's tried 60 some odd cases. So I put every bit of weight into that. Listen, I'm not saying I'm the smartest lawyer in the world. I just outwork the other side. And that's what's reflected in my bills. I outwork the other side because Mr. Sakala is much smarter than I am. He's a better trial lawyer than I am. I just beat him this time. He said that my client is uncollectible and throwing good money after bad. This plaintiff attorney told me in no uncertain terms he's going to go to trial because everybody always backs down to him. His irrational acts and the irrational position taken by the plaintiff, whether it's the counsel or the client, made it clear that I had no choice but to prepare for trial. He said the firm had no prior relationship and refused no other cases. Well, listen, I could have taken on work.
Judge, I did not testify.
Stop. Just be quiet. Just be quiet, Mr. Sakala.
I didn't testify.
I could have taken on work that was higher than $400 an hour. I didn't because that's pretty close to capacity. And I knew this trial was going to last a number of days, and it did. I said, well, Ms. Combs could have just tried the case. She's an appellate lawyer. She's never tried a case in her life, probably never will. He doesn't get to choose who tries the case. I think that's sufficient. I would sure like to see Mr. Sakala's bills, his hourly rate, and his retainer. Maybe he just decided to do it all for free. I don't know, but I'll just accept the court's ruling unless you have any questions, Your Honor.
No, I don't.
Can I respond, Judge, a brief
No,
response?
you cannot. It was his motion. No.
Gotcha.
This case is premised at this point in time when we look at the costs on the wood factors. The court, I believe, previously dealt with them as the court got to the point where it determined that costs and fees would be attributed, but it would needed this evidentiary hearing as to determine the exact amount. But I'll reiterate this: the skill and time and labor involved. We know that maybe this was a one-count complaint, but we know that there was a lot involved. There were experts, there were multiple depositions, there was back and forth, there were multiple motions in limine that were argued, and generally speaking, a motion in limine will help to streamline the case. So Lord knows how this case would have developed if the court had not had the motions in limine to try to streamline some of these issues. And as it's been indicated, the majority of the motions in limine that were filed by the defendant were granted and the plaintiffs were denied. So there was a lot of time and effort that went into this case, even though maybe it should not have. The court also notes that the depositions were extremely lengthy, and as a result of the length of these depositions, the court subsequently instituted a policy which some of my other colleagues adopt, that there's a limit on Dabini essay depositions. I limit mine to 2 hours, but some of my colleagues limit theirs to an hour. But the inordinate amount of time that was spent on these depositions was the impetus of the court setting a limit for these depositions. And that was something that we had to deal with that we shouldn't have had to deal with. Additionally, the likelihood of the success. We know that the case was evaluated for $80,000. There was an offer of judgment on the table, but nevertheless, at the trial, the plaintiff asserted a demand of $600,000, and that also led to the necessity of having to go forward due to the claimed amount that the plaintiff had asserted. We know that Mr. Weaver could have accepted other cases during this time frame. However, as a result of the time that he had to attribute to this case, he couldn't take on any additional files and it did take away from his time working on other files. The fees customarily charged, the court did hear and did review the state bar economies of law, and the court notes that Mr. Weaver did assert a reasonable amount. There are a number of areas where Mr. Weaver could have charged significantly more, but based on a lot of the factors that are involved in this case, and for this particular case, he only charged $400 an hour, and the associates charged $290, which were reasonable and below the average rate that are recommended by the State Bar of Michigan. So those rates are appropriate. The amount in question as a result and the result achieved, as the court previously indicated, the case evaluation was $80,000. The plaintiff requested $600,000. The defendant made offer of judgment of first $500, then $1,000, but the jury came back with a no cause of action in this case. So it was more in line and favorable to the defendant. The expenses incurred were reflected in Exhibit 7, and Mr. Weaver articulated those expenses that were incurred from the time frame which are permissible under 2.405. We know in terms of the time limitations imposed by the circumstances, this case shouldn't have taken 7 days, but it did take 7 days. So we had to deal with it. There were multiple subpoenas that were proffered, and even though all of them weren't called, the defendant had to prepare for them. The relationship with the client, even though Mr. Weaver indicated that he didn't have a prior relationship with the client, he's indicated that this was a situation where the defendant had two prior attorneys on this case, and Mr. Weaver was the third, and Mr. Weaver assumed the responsibility of being able to go forward with this case to its end, and he did so. Professional standing experience of the attorney, we've been through that. We know the bio of Mr. Weaver, and he's a capable, competent attorney. Has been practicing over 35 years with Plunk & Cooney, and is a equity partner and has been since 1997. He's practiced in a number of other states and has been pro hoc into a number of other states. And this was a case where Mr. Weaver took on this matter as an hourly rate versus a contingency rate. And he did, as I previously indicated, his rate was $400 and associates were $290. Based on all the foregoing, one, there's been a representation that the time spent on this case was not reasonable. And Mr. Weaver had indicated that some of the time he spent was not even recorded or reflected in his actual cost that he had presented to the court. So if he had dealt with all of the time that he spent, it probably would be greater than that which he articulated to the court. So the court is satisfied with the hours. The court knows that there was a significant number, 10 motions in limine that were filed, and it would have been more if Mr. Weaver had prepared them himself at his rate of $400 an hour. And of course, even after they were prepared by the associate, he did have to prepare for the matters to be heard before the court. So his preparation was reasonable, as well as the preparation of the associate who prepared the motion. And as the court indicated previously, that this helped streamline the case, which took longer than it should have, and it would have been excruciatingly long if we would not have ruled on those motions in limine. So the court finds that it was appropriate for the associate to prepare the motions for filing, and Mr. Weaver to prepare the motions to be argued in front of the court. That being said, as well as the costs that were involved, as Mr. Weaver indicated, it's acceptable to use those transcripts and those IMEs that were before the trial started, because they did use them in the course of the trial. So all of those costs are permitted. Therefore, court finds that the attorney fees that Mr. Weaver asserted in this action are appropriate. I think initially there were $61,951, but based on the additional cost for today, I think the total fees that were requested are $62,482.91. The cost in the amount of, I think my math is wrong, let me know, 12,835, and the expenses in the amount of $25,893.07. I didn't do the math to total that up, but hopefully, Mr. Weaver, you wrote down those numbers, and
I
that
did.
total, will be the total that is permitted. Mr. Weaver, prepare an order presented to the court for entry, and the court will sign the same.
Your Honor, I don't
Thank
have
you.
the cost. I don't know if that number's correct. It was the expenses were in the expenses section. The total expenses was 25,893. So I don't know where the court's getting the 12,835. There was no application for cost in this case.
Exhibit 10 and Exhibit 7 are the two documents. One is 12,008 something, the other is 25,8 something. The total, Your Honor, 38,725, but I'll include that along with the 62,482
Right.
0.91.
So what that is, the 12 and the, I can't remember the other number. Those two numbers total the 38.
Yep,
Correct?
that's
And
right,
then-
Your Honor.
And then the 62,000, I chose my 428.91.
428, 480, okay.
I think that's what I saw. I don't know if that's what I got off of page 9 of the brief, because I know initially I saw 61,951, I think, and then as a result of today, the 1,500 today, I think that's what brought it up to the 62,428.91. Am I
Okay.
correct?
I'll prepare the order then, Judge.
Your Honor, for the record, there was no exhibits offered into evidence at all, and any request for cost would be outside of the court's previous motion. There was no application for cost in this case. Those costs would all be prior to October 20th.
Whatever fees that are articulated in Mr. Weaver's brief, the litigation expenses, correct me if I misspoke, the litigation expenses.
Prior
Thank
to October 23rd of 24. So filing fees, service.
I articulated what I was in there. They're set forth in Mr. Weaver's brief. The total.
Judge, I think you're right on that. On the hours, so we're 61,951, and we have an additional probably 3.5 hours between Ms. Griffin and I, times 400. So that'd be another, I don't know how much that
I'm
is.
sorry, that's, I'll talk to 300. 400 times 3.5,
Yeah,
it's $1,400.
$1,400. So I'll add that to the 61,951, and that'll be
Thank
the
you.
number for the fees. All right, Judge, thank you.
Thank you. I'll look for that to be submitted to the court for entry.
Thank you, Aaron. Take care.
Thank you.
Bye-bye.
Bye.
Bye-bye.